What do you? Yes. Okay. No, that's fine. Is he sitting in for Reppy?
Yes.
Jim. Okay. Okay. Are you going first?
No. Okay, thanks for coming back. Next chair is the ad hoc chair, Matthias Reimann from Michigan, who will now, in the system of mutual recognition, recognize and present this panel and be strict on everything.
I was appointed chair about 1 minute and 25 seconds ago, so I claim no expertise in this. And I'm not into long introduction. You probably all know, if not personally, then of Richard Fentiman, who is leader in Cambridge. You can see his long biography with all his accomplishments in the materials. What it doesn't quite show is that he's not only a prolific but also a very combative writer, and writes very interesting and readable stuff. And you know all. Then there's this guy, Ralf Michaels here, who's from Duke University School of Law. And Bill Reppy is sick, and his paper will be presented by one of his students. I don't know why Ralf appointed me on a panel of which he's a member, because he knows me. I'm a brutal timekeeper. So 15 minutes, and at 16, I really start making noises. And at 18 or 19, I'll just cut you off. So be warned. I think you go first. I get first. Yep. Oh, right.
I'm great.
Here we go. Yes. And this is 5, and this is 2, and then this is the yellow card.
Well, since
This is the red card.
Well, I shall try to live up to my newfound reputation of being combative. If you attempt to shut me down, I think we might need to have somebody interceding if that's the case. Very well. I'd like to begin just with a quick word of thanks. I know time is short, so I'll just make it quick. That's to say, a thanks to Ralf. I remember him as a student. Let me say he was one of those exceptionally bright students in the class who had a tendency of asking you the question which forced you to resort to the, perhaps we can discuss that afterwards, gambit. I wonder if students know the full significance of that remark. Very well. I'm not going to begin, as you will think is customary on an occasion like this, talking about a topic like this, a theoretical topic, by invoking the name of Savigny. Instead, I'm going to invoke the name of that well-known private international lawyer, Confucius. Or at least, I'm going to cite a Confucian saying. It's the well-known saying, "May you live in interesting times." I think in the West we tend to take this as being a kind of friendly salutation. It is, of course, so my friends more expert than I in these things tell me, a curse. Because in the Confucian scheme of things, interesting times means uncertain times, confusing times, things where the natural stability and order of things is no longer present. Well, we certainly live in interesting times in private international law in Europe, or at least that's how it seems if you live and work in Europe. But the question that I want to address is whether, for you, we live in interesting times, whether the European conflict of laws revolution, and I will, of course, at some point say whether I think there is one or not. The question is whether that conflict of laws revolution is interesting for you, and by you, I really mean an American audience. I must come clean at once, of course, and say that I have a split personality on this occasion, because I am a common lawyer, but I am also a European lawyer. So I need to orientate myself both with my American and with my, I was about to say European, other European colleagues. What am I, and what standpoint am I going to take on this occasion? Well, first of all, I am a European. I make that rather obvious point because it's very important to realize that I am a participant, not an observer, in the conflict of laws revolution in Europe. If I may say so, although I would, I'm sure, blame nobody in this room for this faux pas, there is a tendency in the United States to assume that somehow in the United Kingdom we are not fully part of Europe. I'm bound to say there are people in the United Kingdom who take the same view, but nonetheless, I do not speak to you as an outsider, but as an insider. But I am, of course, a common lawyer. But if I can paraphrase the immortal words so often used in Star Trek, I am a common lawyer, but not as you know it. That is to say, English common lawyers are different from American common lawyers, and I need to make this point before I go further. The first point to make, I think, on this occasion, is that although I am a common lawyer, an English private international lawyer, we never experienced anything like your choice of law revolution. That is very important. Not only did we experience nothing of the kind, but we gave yours rather short shrift. There are numerous articles clogging the English journals pointing out why we couldn't possibly have interest analysis and why we couldn't possibly have the restatement. I suppose there's an interesting reason for that, and that is, of course, that we never experienced American legal realism, or indeed English legal realism, so we never participated, as it were, in the more general methodological revolution, of which it's always seemed to me the American conflict of laws revolution was part. I should say that we had a brief dalliance with the second restatement in relation to tort. Our famous case of Boys and Chaplin, of course, was decided rather mysteriously, as if the second restatement applied in the House of Lords. We also have at least one remarkable decision of the English courts in a case called Johnson and Coventry Churchill, where the English trial judge, with immaculate precision, applied every one of the desiderata in Section 6 of the American Restatement in a tort case. But that is all gone. That was a brief dalliance. The effect of our new, well, they were our new 1995 statutory choice of law rules in tort is that it was effectively no longer possible for the judges to go down that road. So we didn't have an American Revolution or indeed an English Revolution. The third point I want to make here is that for us, choice of law is really unimportant. I'll just let that thought hang in the room for just a moment. Since we are talking methodology in choice of law, I mean that in a very important way, and I think this is going to bear on the methodological questions that I want to discuss. It is very rare indeed for the English courts ever to hear a substantive choice of law dispute for the purposes of deciding, for example, somebody's liability. That is because almost all choice of law disputes in the English courts arise as an integral part of a jurisdictional dispute. The vast majority of cross-border disputes in England are disputes relating to jurisdiction, questions of forum conveniens, and if not those things, then interim remedies. It is so rare, the occurrence of a genuine choice of law dispute, that I would open a bottle of champagne, take my wife out for dinner or something of that sort. That is important, because if you ask yourself, why don't we in England have a sophisticated choice of law methodology like you have in the United States? One reason is, if these disputes arise in interlocutory proceedings, where the standard of proving what the applicable law is the standard of a good arguable case only, it's very difficult to get worked up about how you resolve that particular question. My final sort of preliminary point, just saying what is different about the English and the American approach, and it'll be obvious, I think, from what I've just said, is that we have no choice of law theory. One only has to look at the introductory chapter of Cheshire and North's book on private international law to see the authors basically telling you that. There are pages of interesting discussion about American approaches and Savigny and so on, and then a paragraph saying, but of course this is all very interesting and theoretical. We don't have any theoretical approach like this because our approach is simply pragmatic. I'm reminded here, just to illustrate this important point, of a famous case in the 19th century about the English concept of domicile. It was the first of the big domicile cases, which almost always involved people returning from colonial service in India and wondering where they were domiciled. It was a very important case in which counsel had basically cited all the leading European authorities, including Savigny. Famously, Lord Cranworth, the then Lord Chancellor, said that he couldn't understand why he'd been subjected to this barrage of erudition on the part of counsel, since domicile meant your permanent home, and if you didn't know where your home was, no assistance from Professor Savigny was going to help you. But having said all this, we are united, the English and the American common lawyer, in two important ways for present purposes. We're united, I think, first of all, in our view of uniformity in choice of law. Secondly, and it's a related point, we are united in our view of the role of adjudication in the choice of law process. As to uniformity, we have never believed, I think, English or American conflicts lawyers, that the goal of uniformity of decision, as opposed to having uniform rules, which is a different thing, we have never believed that uniformity of decision is anything other than something sort of connected with forum shopping, which is sometimes a bad thing, but actually on reflection, forum shopping isn't really that bad a thing in most cases, so in that event we're not concerned about uniformity of decision either. It is an important point, I think. You will find, as of course you find in the restatement, you'll find it in also in English books, references to how, of course, something you would have to take into account in designing a choice of law rule is uniformity of decision. But you would never find, I think, an English or an American conflicts lawyer subscribing to the belief that this could ever be the overriding goal. However abstract and far off, you would never think of it as being the overriding goal. That, I think, we share. And it's important, I think, when we come to look at the European Revolution. A related point has to do with the central role of adjudication in the choice of law process. We all, I think, in England and in the United States, take the view that the judge is at the very heart of the choice of law process, that the choice which is being made is a choice that is being made by the judge and not a choice that's being made by the legislator. Not in all cases, of course, because there will be easy cases where you can have a simple legislative rule. The point I'm making is that we believe that there will be hard cases, perhaps in tort cases, most cases, in which the judge must be at the heart of the process and exercise discretion in accordance with principle in deciding what the applicable law shall be. It seems to me this is allied to three characteristics that we share. First of all, a belief that some conflict of laws problems are so complex, especially in the tort area, that they simply do not submit to any hard and fast rule, that it's simply necessary to respond in a sophisticated way to the complexity of the fact situation and the balancing of interests and policies that might be involved to have a discretion on the part of the judge. I think we also believe that it is legitimate from a philosophical, from a constitutional point of view, for the judge to exercise this kind of role. And we also believe that it is feasible. We don't doubt, I think, in England or in the United States, that a judge is capable of making the kinds of determinations which, for example, the American Restatement Second would expect him to. I've always been puzzled, I should say, in the discussions that I've had over various of the European instruments which are on the table today. I've always been puzzled by the argument, and I've heard it actually more than once on the part of officials of the Commission in particular, that you can't have a rule that is too complex to resolve a choice of law problem because the judge in Gdansk, I've never known why the poor judges of Gdansk are singled out for this purpose, because the judge in Gdansk could not be expected to do this. The argument always is, it's all very well for the judge in the commercial court in London to do this, but you can't expect the judge in Gdansk to do this. So, with my sort of split personality revealed, but with my credentials as a common lawyer for this purpose also revealed, what do I think of the European choice of law revolution from a methodological point of view? Let me say, first of all, that I think it's very easy to be seduced by Rome I and Rome II in particular. And I think that some of my colleagues at home have been seduced by it, because you look at it and it looks basically okay. There's a detail here you don't like, a detail there, but when it comes down to it, there's a rule, there's an exception. It's sort of what we have already. So it may be the worst you can say of Rome I and Rome II, and I'm going to use those as my two examples, is that they are dull. Oscar Wilde, who always thought that being dull was the worst sin anyone could commit, would not have been impressed, but it's not particularly a bad thing in legislation that it should be dull. In fact, I think they are both more interesting and more different. Some of my colleagues would say more dangerous. I don't take that Eurosceptic view than that would suggest. So let me tell you what I think is interesting and different from a methodological point of view about Rome I and Rome II in particular. First of all, and we had hints of this morning in Simeon's remarks, they use a remarkably unsophisticated choice of law technology. Surprisingly, since he, and actually I, because I was also present at that rather aggressive meeting of the European Parliament in Brussels some time ago, he and I basically attempted to show them how sophisticated the rules could be. I want to pick on one example of this because it's revealing. Both Rome I and Rome II use the close connection formula as the vehicle for the flexible exception. They don't use the alternative, which is a significant relationship formula, which was in fact the formula that was used at common law in England in dealing with tort cases and was borrowed also in our subsequent statute. It seems to me that this apparently innocuous linguistic difference conceals something quite important. Close connection could, of course, in the hands of an instrumental judge, turn into significant relationship. But there is a conceptual distinction. Close connection is about territorial connection. It does not involve the evaluation of policies, expectations, interests, and so on, which we would associate with significant relationship. English lawyers tend to believe this doesn't matter because they can always turn close connection into significant relationship, simply in giving effect to it. But it's important to realize that a real distinction was intended by this formulation. And I know this because I was present at the same meeting as Simeon, where it was made very clear to us that there was meant to be a distinction. And it's this. It has to do with the judicial role. It has to do with the fact, so we were told on that occasion, that a judge can be expected to ascertain close connection because it involves the identification and assessment, whatever that means, of territorial connections. And that is something a judge can do and should be entitled to do. It's a different thing, however, we were told, to have significant relationship, because that involves the judge in doing things which the judge should not be involved with. How it is possible in practice to have a coherent, I'm trying to be combative here, how it is possible to have a coherent choice of law test which does not involve an assessment of the matters which we would associate with significant relationship, I cannot imagine. I mean, is it really the case that we simply add up the connecting factors and decide which law wins on the basis of how many there are? That's my first point. The second point I will just allude to, because to explore it at great depth would take me far beyond my 15 minutes.
2 minutes.
Okay. And it's simply that one should not forget the hidden fault lines that underlie Rome I and Rome II. In particular, the battle that was fought over Rome I to turn it into something which is as innocuous and puppyish as it may be. I won't go into all the reasons for that, but let me say that if you want to get a feel for the real methodological battles being fought in Europe over questions of private international law, then look at the battles that were fought especially over Rome I, and in particular the reaction of the United Kingdom to Rome I, which led us, of course, not to opt into the original proposal. It seems to me that interesting methodological issues that we can come back to lie behind that. But it seems to me, and I'm gradually working towards a conclusion, it seems to me that there are two more significant matters that have to be addressed, though. Two more significant methodological features which one sees in looking at Rome I and Rome II, things that would surprise the common lawyer, things which make them interesting, if you like. First of all, it seems to me that the new European conflicts regime contains at its heart a strong commitment to certainty of decision. I don't mean that in perhaps the rather trivial sense that it contains rather more technical rules than I would be used to, because of course you're going to say, yes, but there are some flexible exceptions built in as well. I want here to make the point, it's a more general point, that in order to see what really underlies the methodological assumptions and philosophy of the revolution, you can't just look at the text. The point I'm making is not that the text is tighter and more closely drafted than perhaps our rules certainly were in England beforehand. The point I'm making is, to get a real flavour for the approach and the methodology, you have to ask yourself, what will the Court of Justice do with this document? We've not mentioned that today, but it seems to me the Court of Justice is the elephant in the room. In fact, it's the great woolly mammoth pawing the ground ready to attack. The point I want to make here is that if you look at some of the recent decisions of the Court of Justice, in particular, and no English lawyer could ever speak about private international law without mentioning this case, in particular, do you want to say it for me? In particular, in Owusu and Jackson, which is about so much more than forum non-conveniens, you will find a strong commitment to the overriding importance of certainty of decision. I mean, to cut a long story short, it was the case in which the Court of Justice said that the English doctrine of forum non-conveniens, which is of course discretionary, is incompatible with the principles of the Brussels Convention, as it then was. But it seems to me the more important message that we get from Owusu, which is very important in the context of our discussion, is this. Owusu tells us that the European private international law regime is all about the internal market. It is all about integration in the community. It is all about serving the needs of the internal market. I won't go into all the detail about why Owusu and Jackson says that, but let me just make this substantive point. It's about a different issue, but I think it has wider implications. One of the issues in that case, the key issue, concerned the scope of what was then the Brussels Convention, and whether it prevented an English court from declining to exercise jurisdiction in favour of the courts of a non-member state. It will come as a surprise to, I think, many of the Americans in this room to learn that the Court of Justice said that the Brussels Convention did apply in that situation to regulate the allocation of jurisdiction between a member state and a non-member state, and ultimately, of course, it prevented the English courts from using their traditional rules for doing that. The point I want to make here is this. The Court of Justice rode roughshod over the argument that the specific purpose of the Brussels Convention was to ensure the mutual enforcement of judgments between member states. They committed themselves instead to the view that that was trumped by the consideration that the internal market and giving effect to European integration was the ultimate purpose of these private international law rules. That is really the point that I want to make. This, in a way, is my conclusion. It's that you mustn't fall into the trap of thinking that these conflict of laws rules are about finding the best conflict of laws solution to a particular problem. This isn't people sitting down in a room saying, what is the best rule to deal with the assignment of debts? What's the best rule to deal with choice of law in tort? It's about finding the rule that best serves the higher objective of European integration. And that leads me, of course, to the question that I want to ask people in the room. Why should you, and I address the American lawyers here, be interested in that? In a sense, these instruments are not interesting. They are only interesting if you are prepared to share the objective which ultimately they serve, which is integration in a, if I can use the expression, a common market. It's important for me, it's interesting for me, but why should it be interesting for you? Unless, of course, you think that you want to share those objectives too. I'm not saying you should join the European Union, but it does seem to me the really interesting question, again raised by Simeon this morning, is this. Do you want to tie your choice of law rules to this wider project of integration? In other words, in American terms, are you going to commit yourself to federalism in matters of choice of law? And it seems to me that is actually the crunch of the issue between us, between the Europeans and the American lawyers on this occasion.
Thank you very
much. It is, of course, risky to speak right after your former teacher. If he praises your intelligent questions, I should probably also ask him to retroactively improve my grade that I got in conflicts in the end. But it hasn't hurt me, fortunately. My task is modest because all I want to do is to defend the title of the conference, A New European Choice of Law Revolution. And some of that has been done already, so I'm very glad I can cut over that. The point is not to make that this is a good thing necessarily. In fact, I am here only because I invited a professor from France who was so upset even by the idea that this could be a revolution that he decided not to come, and that's why you have to bear with me. But I want to raise our attention that this goes beyond just the codification of rules that we had before, that this should well be viewed as a European revolution. So I want to speak about what we mean by revolutions in choice of law. I will probably skip over the three pillars of traditional, that is 19th century European choice of law. I'll briefly look at three aspects where I see an actual revolution of choice of law, and then in the remaining 18 seconds that Matthias will give me, I will compile lessons for the United States. When we speak about revolutions in choice of law, obviously we usually speak about only one revolution, that is the US conflicts revolution that starts around the 30s, has its high point in the 60s, and then at some point wavers out and has successfully abolished what was there before, but has not entirely left us certain about where we are at this moment. Now, why is this a revolution? As Simeon said this morning, not so much in the results. Many of the results have to do with guest statutes and the question of the capacity of married women, which are not the prime problems anymore. But certainly with regard to the paradigmatic way in which we think about choice of law. We think about choice of law dramatically differently today from how we did 80 years ago in the United States. And that's the important change from the revolution in the United States. And if we then think that we've become so much smarter, then we should wonder why the revolution was so unsuccessful in having an impact on Europe, because the impact on Europe was relatively limited. There was a lot of interest in Europe, but ultimately the revolution did not have a huge success. And I would say that the main reason you can find in a quote by Brainerd Curry, and that is this: almost all constructive writing on conflict of laws in this century and in this country, the United States, has been in revolt against this heritage of Joseph Beal's vested rights theory. And that reminds us that revolutions, of course, are always reactions to what was there before. So the American Revolution needs to be understood as a reaction to what was there before, and what was there before was the first restatement and the vested rights theory. And that provides us with a reason why that revolution had limited success in Europe, because we did not have a vested rights theory in Europe. The vested rights theory, before it became big, was rejected by Wächter and Savigny and never really turned into a theory of choice of law. What we have sometimes looks deceptively similar to Americans because it's also based on rules, it's based on unilateral choice of law rules, it's based on territorial connections, but underlying that is a very different idea of choice of law. So the European formalism, if we can call it that, is not like the first restatement formalism. And if we want to see a European revolution, we should not look for something similar to what we find in the United States. And that applies to three things. First, in terms of actors. Obviously, the actors of the US revolution were largely courts and scholars. And courts, with the exception of the Supreme Court, because although, of course, interest analysis is based on some earlier Supreme Court cases, during the actual revolution, the Supreme Court stays out of that. If we find a European revolution, it is a revolution first and foremost done by the legislator, the lawmaker, the European legislator, and by the highest court, by the European Court of Justice. Second, if we look for a revolution in terms of object, it may not suffice to just look at the texts of Rome I and Rome II and have this kind of formal idea of what we mean by choice of law. We'd have to look at developments in Europe in their entirety and what they mean for choice of law. And thirdly, in terms of criteria, how do we recognize a revolution? We might have to move beyond the criteria that we have in the United States between rule selection and jurisdiction selecting rules, between rules and the standards approach, between unilateral and multilateral approaches, and see rather whether what we find in Europe is a revolution against what was there before. So in order to find out whether we have a European revolution, we'd have to look at what was there before. I call this the new European choice of law revolution because, in fact, there were four, but I will not bore you with the first two, which are the 14th and the 17th century. The 14th century has been mentioned, fortunately, this morning already. We find that both of those, all of these revolutions come together with changes in the political infrastructure. The 14th century with the emergence of city-states and their statutes, the 17th century with the emerging of sovereign states and the problem of their relations with each other, the 19th century, which now interests me, with the emerging of a public-private distinction where private international law is distinct from public international law, and we have a private community of nations, and the 21st century, obviously, with the establishment and growth of the European Union. So these go, and I won't spend much of my time on these people in part I asked Matthias to chair this to cut myself short because my notes are too long. But there are 3 elements I put to you that are important in European choice of law in the 19th and in the 20th century, and that are different from the vested rights theory in the United States. The first would be to view private international law, choice of law, as an expansion of private law, not of international law. And that is a heritage from Savigny, who reinterprets comity that he borrows from Story, takes it out of international law, and turns it into a private law device. So we have all the public laws that are separate and that he does not deal with, but we have this community in the private section. And in an ironic way, you could say that Savigny and Curry do not at all disagree about how private conflicts and public conflicts should be resolved. It's only that for Curry, all conflicts are public conflicts between governmental interests, and for Savigny, there are no such governmental interests in the private law area, and for that reason, you have to devise other types of rules to deal with those. Second important element in this would be Mancini, who establishes importantly that nationality becomes an important connecting factor in choice of law over domicile, which would be a territorial and apolitical connecting factor that Savigny had proposed. The idea then is that private international law is politicized on the basis of the nation as connecting factor, but the nation is different from the state. So we talk of the interests of nations and the interests of nationals, but not the interests of states and their governments. That is confined to public policy exception. The main part of this is politicized, but still private international law, dealing with private relations that Mancini deals with either on the basis of nationality, personality principle, or on the basis of party autonomy. So if you saw earlier how Simeon showed the much broader range that nationality and personality has in European versus American choice of law, then one reason is the higher importance of a personality principle, and the second is a lower emphasis on territorial sovereignty, which plays a very limited role in choice of law. And then third, I named Bartin and Kahn, and then I found that I can't find any pictures of them on the web, so you have to imagine what they look like. And that is the formulation of actual choice of law rules as rules. So choice of law moves away from an element of international law or an element of natural law or law of reason and turns into domestic law. There are domestic choice of law rules. But the character of these choice of law rules is what is so important. These are, on the one hand, domestic, but they are separate from substantive law in that they designate the applicable law, but they are separate from the substantive law itself. We have, of course, some such elements in Beale. Beale writes the same, Dicey writes the same to some extent, but ultimately you could say that the vested rights theory is an a priori approach as to what law applies and is not based really, although Beale claims it does, on the actual domestic approach to choice of law rules. This combination then makes private international law in Europe more resistant to American approaches than the vested rights approach would have been. So we have choice of law as a private law. We have these main connecting factors. We have this mixed nature of choice of law as domestic in nature. We have domestic rules, but international in focus. They focus on an international community, and they are typically multilateral. And that leads to a decentralized approach to choice of law. Each state has its own choice of law rules, but there's an ideal of uniformity in choice of law rules to be achieved by treaty. And that means, because we have these choice of law rules that have a political background and that are based on domestic law and domestic politics, it's not too difficult to implement something like interest analysis in this, what happened in the 20th century. The French idea is that something like interest analysis, unilateral approaches, builds a second pillar of choice of law, but the winning approach, you could say, is to say we can implement these interests into normal choice of law rules. We can characterize the public policy exception as a choice of law rule designating the law of the forum to apply. We can use policy considerations to devise choice of law rules for the protection of weaker parties, consumers, employees, insureds. And we can use even provisions on overriding mandatory provisions, as Article 9 now in the Rome I regulation, as a specific choice of law rule that determines the applicable law. So this does not have to lead to the methodological change as it did in the United States, where the implementation of policy considerations alone more or less killed the first restatement. Someone said earlier that revolutions always kill people, and the one person, of course, that the US Revolution killed is Joseph Beale. And whenever young people write in the US about conflict of laws, they spend the first 2 pages to just kill Beale again. That's the kind of ritual that you have to engage in when you write about conflict of laws in the United States. Now, why is this then different in the European Union? Because in the end, all these 3 elements that are named, the private character, the national personality character, and the domestic character of choice of law, are overcome through Europeanization. The first thing is the thing that Richard just called as puppyish and innocuous, and that is the federalization of choice of law rules. So the idea that all that we're doing is codifying rules on the European level. Of course, as many of you know, there's a huge debate about the codification of substantive private law, and lots of debate in Europe. Relatively little debate has there been in the conflicts area apart from England, and of course in France, where you find 100 private international law scholars writing an open letter opposing it, and another 100 private international law scholars supporting it, which shows you the breadth of private international law in France. I'm not sure we would find 200 in the whole of the United States. This looks innocuous because if we have these rules that are multilateral, the next step would be to enter into a treaty as we did with the Rome Convention. And we could think that establishing, turning the treaty into a federalized choice of law regime really does nothing more than change the form of what otherwise is going to be the same choice of law regime. But if you see what happens is that we move from an interstate relation in which compromises are going to be made between the ideas of individual states on the best rules of choice of law. This turns easily into a centralized, hierarchically superior instrument of EU policies. The first thing that happens not so much in the Rome regulations but beyond those is that we find a distinction between intra-member state conflicts and conflicts with other states. And the second thing, obviously, is that the policies that go into this choice of law regime are now going to be EU policies rather than member state policies. I won't talk too much about federalization because Matthias will do so later. I'll just leave 3 markers here. The first is the delimitation towards third countries. We have a decision from 2000, Ingmar against Eaton Leonard, in which the Court of Justice effectively held that a choice of law clause between a Californian distributor and a commercial agent active in England, choosing Californian law as you normally would as a distributor, was not enforceable because of fundamental policies of protecting commercial agents within the European Union. That was remarkable because the basis for that provision, the inspiration for that came from French and German law, and both the German court and the French court, after the ECJ decided they probably didn't follow that law too closely, held that these were not internationally mandatory rules, so they could be overruled through choice of law regimes. Obviously, the Court of Justice, at least in this case, takes a stricter perspective on protecting public policies within the European Union vis-à-vis third countries. We'll have to see whether that continues, of course. But that would be one sign to show how we have a distinction between interstate conflicts and conflicts with third countries. Second element here would be the use of the choice of law rules to implement European policies. One such example was named earlier, environmental protection. The idea that the ubiquity principle, that is, that the plaintiff can choose whether the law of the place of conduct or the law of the place of injury should govern, is meant to lead to a higher degree of protection of the environment, and the reason for that is that this is an EU policy. The EU has a policy to protect the environment, and that's the basis on which this choice of law rule is justified. That's quite different from a decentralized approach in which individual states in a decentralized way try to achieve such similar policies. And then thirdly, of course, and Richard mentioned that before, the relationship between the innocuous, puppyish Rome regulations and everything else that we have in European Union law was hugely contested already. Shocking. And effectively has remained unresolved because the Rome regulations don't speak about this anymore, except saying that the proper functioning of the internal market is left to other instruments. So, in fact, what we have is an unresolved situation in which European rules are going to govern. If I only have 2 minutes left, I'm shocked, and I will not speak a lot about this point, so you just have to trust me on that. I will speak, though, about the question of pluralization of method. So we have the traditional choice of law rule turned into a supranational allocation between countries. We have, secondly, public interests of member states that we had before, but limited and regulated by European Union law. And then thirdly, we have regulatory interests of the European Union coming in, first as an influence on choice of law rules, and second in the way in which they interfere with choice of law rules. So just to bring one example, typical choice of law problem to decide between a place of conduct and place of effect. We could also decide between the place of the seller and the place of the buyer, place of conduct or place of effect, some of those problems. Normally, we would apply the closest connection approach in traditional choice of law. Now we have a whole method on the one hand to bring in public interests through overriding mandatory provisions, and we have a whole other method on the basis of mutual recognition, country of origin, vested rights. The question whether corporations established in some country have to be recognized, whether same-sex marriages established in one member state have to be recognized, even if that member state is not the one with the closest connection. And this conflict between closest connection on the one hand and considerations of mutual recognition and country of origin and questions of public interests of destination countries is now going to be regulated on the basis of European Union law. So what we have is a conflict of laws, a conflict of methods of conflict of laws in which the old Savinian approach is only one of the ones that we have. So what does that mean for the United States? Because I didn't tell you everything that it meant for Europe, I can't tell you everything that it means for the United States, and I indeed have only 18 seconds left. But the first question is federalization something that is going to happen in the United States? The likelihood, of course, is low. The interest in federal regulation in general is only insular. The interest of the federal legislator in choice of law has been even lower. The question is that, however, once we realize the regulatory potential that choice of law rules have, federalization of at least specific rules of choice of law may be a more attractive object than the federalization of substantive law. What we have so far is negative and largely irrelevant things like like DOMA, but we could have positive federal statutes of choice of law that actually would be very effective. The second is constitutionalization. I just put down here the comparable bases under the US Constitution to the ones that we have in Europe. We know that in the United States, constitutional law after the trilogy in the 80s has become all but irrelevant to choice of law. And we see a development in the European Union where the Constitution is actually instrumentalized very strongly towards changing choice of law rules. And it remains to be seen whether that could have any impact on the United States. And thirdly, of course, the question whether this methodological pluralism, in which we have a closest connection approach first, second, one of public interests, and thirdly, one of private interests and private rights, in which ultimately the conflict is between those private rights and the public policies for a large part, would be something more attractive than, on the one hand, monolithic theories of choice of law in the United States that have always proved to be insufficient, and on the other hand, the kind of eclectic approaches, as in the second restatement, that have been unsatisfactory because it was unclear how the conflicts should be resolved. This is also not a conflict that is going to be resolved ex ante, but it is one that could function as a space within which the real conflicts between public policies of states and private interests of individuals could actually play out. And I apologize that I had too many notes. That sometimes happens. Thank you.
In my faculty, we have a policy that for every day you're late with the grading of the exams, you have to pay a $100 fine. It has done wonders in the punctuality of turning in exams. And I always thought that in conferences, we should have a rule that says for every minute you go over time, you have to pay $100 into the common fund, and you could finance whole conferences simply out of those penalties. That would be $200 in the hole.
We finance most of this, so I'm fine.
Once again, Professor Reppy was scheduled to speak and has taken ill, and I'm one of his students. I don't claim to be an adequate replacement for him. Surely few could fill his shoes in the conflicts arena, but I will read some excerpts in 15 minutes or less from his article that he's working on, tentatively entitled Eclecticism and Methods for Resolving Tort and Conflict of Laws, the USA and the EU. From the introduction, there are, to simplify, 3 different theories employed in choice of law methodology to allocate to a state control through applications of its substantive law over resolution of a litigated claim or issue. First, territorialism. Sovereign should have control via its laws because an event has occurred in the land that comprises that state. That actors in the event are from another state is not important. The first restatement's approach, of course, to choice of law in the areas of torts and contracts illustrates this territorialism theory. The second theory is the personal law theory. A sovereign state wants to, and thus to the extent possibly gets to, employ its protective laws for the benefit of its own people, its domiciliaries, even when they get involved in a dispute due to the concurrence of events outside. This approach was the basis for identifying false conflicts as defined by Brainerd Curry. If the domicile of the plaintiff and of the defendant was the same with regard to an issue or claim, then conflicting laws of the place of injury in tort or place of making a contract was to be disregarded. The third approach to allocating sovereignty accords to a state having a connection to a dispute, control of its laws to resolve the matter if its laws best achieve that desired social goal. Sometimes that state will be the domicile of a party, sometimes its connection will be territorial, as in the place of an accident, for example. The pure better law version of Loeffler's 5 choices, five choice influencing considerations, as once employed in Minnesota, illustrates this third theory embodied in choice of law method, as does the approach called favor contractus, sometimes applied the choice of law where the validity of a contract is in dispute. Eclecticism in choice of law occurs when a court combines 2 or possibly all 3 of these theories for allocating sovereignty to create a modern method of choice of law to resolve a multiple state claim or issue that's part of that claim. There are 3 primary ways in which that mixing can occur. The first can be called depassage eclecticism, as when the theory is employed to resolve most of the issues arising in an area of law, but a different theory is used with respect to a particular issue arising out of that same area of law. An example would be a state that uses interest analysis in tort cases so that the law of the domicile of the plaintiff or defendant is used to decide most tort issues, personal law theory, yet chooses the law applicable to conduct regulating tort rules based on the place of the misconduct, territorialism, without regard to the domicile of the parties. The second type of mixing, Professor Reppy calls multiple look eclecticism. The court first sees what choice of law result it will get under one method, maybe territorialism, but if no conclusive resolution of the issue at hand results, then makes a second choice of law inquiry using a different method, maybe personal law, which may result in trumping the tentative solution obtained by a first look. This type of eclecticism is illustrated in the first restatement's choice of law approach to the issue of whether a marriage is valid. First, reference is made under a territorial theory to the place where the contract of marriage was completed. If its law holds the marriage invalid, then the inquiry will end. But if the marriage is valid under that law, a second look for invalidating law is made by consulting the law of the domicile of the parties. Another illustration is New York's choice of law approach in tort cases under Neumeyer v. Kuhner, as implemented in Schultz v. Boy Scouts of America. The court first checks the tort law of the domicile states of the plaintiff and defendant under the personal law approach, and if these laws get the same result, the inquiry ends. If the conflict is non-false, the second look is made, and this time to the tort law of the place of injury using the territorial approach. But that law, too, can be displaced by a third look. Schultz indicates the law of the place of injury will yield to the law of center of gravity if it is elsewhere than in the state where the injury occurred. Center of gravity itself is a prime example of the third type of eclecticism, which Professor Reppy calls big mix eclecticism. The court under this approach looks to the state having the most contacts by examining territorial contracts, such as place of negotiating of making of, a performance of a contract, and personal law connections, including the domiciles of the parties to the contract. The primary second restatement sections that deal with this choice of law in tort and contract cases, sections 145 and 188 respectively, employ this mix of territorial and personal law contacts. And it's possible to read the overarching section 6 of the second restatement as offering up an even bigger eclectic mix by adding in the consideration of the justice-seeking theory of allocating sovereign control over multiple legal disputes. Unfortunately, time is going to limit what can be excerpted here, and this third consideration won't be discussed later on. But turning to second look eclecticism, from the sensible to the senseless, as Professor Reppy says. In regard to choice of law for the validity of marriage issues under the first restatement, a quite sensible use of second look eclecticism is employed by the 1934 first restatement of conflict of laws in stating rules for determining the validity of a marriage. Viewing marriage as a matter of contract, the initial choice of law is to the place of celebration, which coincides with the territorial theories, major lex loci contractus rule. And if that law invalidates the marriage, again, the inquiry will end. If the marriage is valid under that law, the eclectic approach will then shift from the territorial theory to the personal law theory and look for a second look again, this time to the law of the domicile of the participants in the ceremony. If the law of either party's domicile finds the marriage polygamous or so incestuous as to violate a strong public policy of the domicile state, or if that statute of the domicile state provides that the type of marriage celebrated out of state is void, then the domicile law will be applied. This use of second look eclecticism recognizes that marriage is not just an issue of contract, but also a status law issue, and that the interest of domicile states shouldn't be subsumed by that territorial purism. Looking to New York's choice of law method for loss distribution in torts, Professor Reppy starts off in 1963 in Babcock v. Jackson. New York's Court of Appeals adopted the interest analysis, choice of law method based on personal law theory for allocating sovereignty in multiple state cases to resolve the bulk of its choice of law issues. Babcock involved a false conflict between both plaintiff and defendant were domicile of the same state, and Babcock offered up in dictum that in cases of non-false conflicts, the disposition of other issues must turn on the law of the jurisdiction which has the strongest interest in the resolution of the particular issue presented. That is, there would be a weighing of interests. Other refers to issues to be decided by territorial rules and not interest analysis. Thus, Babcock envisioned applying to these other issues, which would involve the bulk of tort law issues, the law of either the plaintiff or defendant's domicile. In 1969, then Judge Fuld, in a concurring opinion, laid out a choice of law rules that 3 years later were adopted by a majority of the New York Court of Appeals, widely known as the Neumeier Rules. Originally dealing with guest statute cases, these rules in 1985 held by New York's High Court to apply by analogy to all loss distribution issues in tort cases. The rules were not artfully written, but federal or lower New York courts understood that cases worked out that Rule 1 was intended to recognize false conflicts of both the same domicile and different domicile, same law varieties. Likewise, where Rule 2 provided no choice of law answer in true conflicts where the alleged tortfeasor acted in his domicile, whose tort law rendered him not liable, while the victim was injured in his domicile, whose law provided for recovery. These other courts found a solution, and the ultimate reference to Neumeier Rule 3 to the place of injury meant that the law of the plaintiff state should govern. As a result, the Neumeier Rules were converted into a choice of law method for tort cases. False conflicts were recognized. Where the conflict was non-false, either A, the law of the place of injury was consulted to break the tie, or B, the law of the place of injury was actually applied. Solution A, Professor Reppy refers to as a sensible mix type of eclectic depassage, recognizing that where one of the domicile states also is a state of injury, it usually will have a greater connection to the tort than that of the other domicile state. Solution B presents legal schizophrenia. If the basic principle is based on an interest analysis and the personal law theory of allocating sovereignty, eclecticism can be used to fashion a tie-break approach for resolving non-false conflicts. This can be done. There is simply no reason to instead drop interest analysis and the personal law theory like a superheated potato and revert to Baelian territorialism as the theoretical basis for deciding the case. The choice between A or B is academic in the two-state conflict, but crucial to the outcome in a three-state conflict where the parties have separate domiciles and different laws, and the place of injury is the third state, especially if the law of the place of injury consists of a rule different from that of both domicile states. Following the Cooney case, at least one or two lower New York courts had decided three-state conflicts in which the result would be different if solution B to the Neumeyer Rule 3 interpretation problem were adopted based on pre-Cooney precedent, or solution A was chosen on the tiebreak dictum in Cooney. Squarely presenting the issue was a 2001 appellate division case, Bodilla v. Transnat Express. The plaintiff in this auto accident case was from Ontario and the defendant from Quebec. The place of the misconduct and injury was New York. Quebec's no-fault statute precluded the plaintiff from recovering non-economic pain and suffering damages, but Ontario allowed such recovery subject to a damage cap, while New York statute was more generous to the plaintiff in regard to those non-economic damages. This was a true conflict, but was not covered by the inartfully drafted Neumeyer Rule 2 because the place of the tort was not one of the domicile provinces. Rule 3 thus applied, and the Bodilla court applied New York law using solution B to interpret Rule 3's reference to place of tort. The court recognized that both Quebec and Ontario had an interest in application of the law of the province to aid a domiciliary of the jurisdiction. The court quoted the tiebreaker passage from Cooney and then, obviously ignorant of its import, held New York law applied rather than holding New York's pro-plaintiff rule required, breaking the tie between Ontario and Quebec in favor of more pro-plaintiff law of these two conferences, that of Ontario. Whether Bodilla misinterpreted the tiebreaker dictum of Cooney won't be known until New York Court of Appeals tells us if solution A or B is to be applied in interpreting Neumeyer 3. And turning to the EU's mixing of personal law and territorial theories in tort cases under Rome 2, while New York's High Court remains free to follow a Rose Law precedent in interpreting Neumeyer 3 is not reverting from interest analysis to lex loci, but instead consulting the place of the tort as part of the process of choosing the states. The European Union seems committed to what Professor Reppy refers to as the senseless second-look eclecticism applied in New York's Bodilla case. The EU rule for choice of law in cases involving non-contractual obligations, known as Rome 2, is like New York's approach in tort cases, a mix of lex loci and false conflict theory. Unlike New York, where Neumeyer Rule 1 has a court first look to sense if there is a false conflict based on common domicile, Rome 2's first look is to the law of the country in which the damage occurs. Second look under Rome 2 is based on personal law theory of sovereignty rather than territorialism. However, where the person claimed to be liable and the person sustaining damage both have their habitual residence in the same country at the time when the damage occurs, the law of that country shall apply. These articles are incapable of the construction that the place of injury functions as a tie-break device when there is a non-false conflict between the laws of two domicile states. It is even likely that these articles will be viewed as requiring application of the lex loci's no recovery rule of country A, the place of the tort, although plaintiff habitually resides in country B and defending country C, with B and C having identical pro-recovery laws. As a result, the Rome 2 mixing of lex loci with false conflict theory is an example of the very most indefensible use of second-look eclecticism. Turning to depassage eclecticism, Professor Reppy discusses primarily the abuse of the concept of conduct regulating rules of tort of law. In the New York experience, Professor Brainerd Curry, the primary creator of the personal law-based choice of law method of interest analysis, memorably commented that a contract to dance naked in the streets of Rome can hardly be considered without reference to Roman law. Curry thus recognized that in some contract choice of law cases, a depassage would be required so that on issues relating to regulation of conduct, the law of the place of performance would govern, although on all other issues, the law of one of the litigants' domicile would govern. Quite possibly the same is true of tort cases. It would be absurd in the instance of two New Yorkers involved in a head-on collision of automobiles on the roads of England to declare there was a false conflict on the issue of whether one should be driving on the right or left side of the road. A territorial reference to English law in that case would be imperative. Babcock v. Jackson, New York's seminal interest analysis case in the area of tort choice of law, recognized that making interest analysis the primary method of choice of law in tort cases could eliminate the need for a territorial reference on some issues. The category of issues to be subject to a territorial reference to the place of misconduct was variously described in Babcock: rules concerning the exercise of due care, rules regulating conduct, rules of the road, and standards of conduct. Particularly the latter term is ambiguous. It could refer to broad categories of negligence versus gross negligence versus strict liability, or it could refer to more specific descriptions of required or banned conduct. Inclusion of the concept of the rule of the road in a list of terms describing the category subject to territorial reference in choice of law suggests the latter, narrower interpretation of the standard of conduct. Unfortunately, the uncertainty about the scope of standard of conduct as describing laws chosen not by interest analysis but by territorial reference was revived by the New York High Court in 1994 with Padula v. Liller Properties Corporation. A New York plaintiff sued a New York defendant for injuries suffered at a construction site in Massachusetts. Under interest analysis, this was a false conflict, and New York supplied all the governing law except for the laws that were conduct regulating. The plaintiff relied on a New York statute that imposed strict liability on the parent if the responsible defendant failed to follow certain guidelines addressing the safety of scaffolding. Since the strict liability rule was annexed to a New York regulatory scheme that was conduct regulating, that regulatory package did not apply in the case because New York was not the place where that misconduct had occurred. In reaching this conclusion, the Padula Court quoted from a 1985 precedent that explained that the conduct regulating exception to the applicability of interest analysis applied the law of the place of tort because of the locus jurisdiction's interests in protecting the reasonable expectations of the parties who relied upon them to govern their primary conduct. Such reliance would not be placed by an actor on the fact that the jurisdiction where he was would hold him liable for his negligence in the situation at hand and would not require proof of gross negligence. Having held that New York's strict liability law did not apply, Padula concluded astonishingly that Massachusetts law was properly applied. But Massachusetts' simple negligence standard could only apply if it were classified as a conduct regulating rule of tort law. The sentence that Massachusetts law applied can be viewed as dictum that lower courts can disregard, and Professor Reppy reviewed the actual holding of Padula being only that the plaintiff could not benefit from a law of strict liability but had to prove negligence without having noted any difference between the negligence law of New York under interest analysis and Massachusetts. Turning to the application of conduct regulating law under Rome II, the language of Rome II used to describe what in New York would be called a conduct regulating rule of law seems sufficiently narrow as to eliminate any possibility that it could be the source of determining whether the plaintiff, in order to recover, had to prove gross negligence, or willful misconduct. The heading for Article 17 of Rome II is Rules of Safety and Conduct, and the text provides, in assessing the conduct of the person claimed to be liable, action shall be taken, as a matter of fact and insofar as is appropriate, of the rules of safety and conduct which were in force at the place and time of the event giving rise to the liability. Bizarre indeed is the notion that a statute in the place of acting mandating certain conduct to assure safety must be treated as a question of fact. Apparently, evidence concerning enactment of the statute must be presented. Apparently, too, in some jurisdictions, the trial court's finding of fact concerning the existence of conduct regulating law would be harder to get reversed on appeal than if the matter were one of law. Apparently, the matter is treated as one of fact rather than law to assure that there would not be a scintilla of depassage in the choice of law method that Rome II prescribes for tort cases. Numerous articles of Rome II employ language to indicate that all legal issues in the tort cause of action are to be decided by the law of one country. And what are the limitation that the conduct regulating laws are incorporated into the litigation as applicable facts only insofar as is appropriate? Is this also a question of fact not to be received de novo on appeal in some jurisdictions? And what circumstances can be imagined to make it inappropriate to find as a fact that the defendant acting in State A failed to abide by a safety regulation of State A that indisputably was in effect at the pertinent time if it is clear that there was such a failure? In conclusion, so long as the not appropriate escape is used only in the most compelling circumstances, then Rome II's incorporation of the theory that some laws are conduct regulating can be sound. Article 17 creates what is, in effect, an eclectic depassage if the otherwise applicable law is that of the common domicile of the litigants, a mix of personal law and territorial law theory, but eclectic if the lex loci otherwise applies, as both applicable laws are chosen by territorial references. Thank you.
Okay, we have 15 minutes for discussion. Ambassador.
We can do 20.
Since the false conflict theory has again been raised, and you have raised it this morning, I would like to make a remark on that. I think it is a theory which is appropriate for the United States, but not appropriate for Europe. Why is that so? You can discover a false conflict fairly easily if you have the materials from the jurisdictions involved. I think an American practicing lawyer can find out that fairly quickly via the net or some other means. Everything is in English. If you have a conflict which involves Estonian and Latvian law, and the case is in England or in a German court, the lawyers involved in these courts will have great difficulties to find something about that law at all. And I mean, think of the operation of the false conflict theory. You first go into the substantive law of the jurisdictions which might be involved, which means you have to make a full investigation of that law. Not just the legal provisions, but of course the case law and so on. All that in the national language. And then you decide, false conflict. You have spent hours and hours on it. I think it is much more economical in a multi-language environment to dispense with this false conflict theory, and I do not consider it as a deficit that we don't have it in the Rome II regulation. Even in the context of Belgium and France, which you mentioned this morning, you cannot rely really on the fact that Belgium once adopted the French Civil Code. The case law has gone very much apart. Perhaps a second remark concerning Richard's analysis, which I agree to, that conflict of laws in the European Union is an instrument of integration. Yes, this is not only politics, but this is law. I recall Article 65 of the EEC Treaty, which says measures in the field of judicial cooperation in civil matters having cross-border implications to be taken in accordance with Article 7 and insofar as necessary for the proper functioning of the internal market shall include, and so on. And then conflict of laws. Now this proviso, insofar as necessary for the proper functioning of the internal market, was introduced at the very last meeting of the European Summit in 1999, where only the heads of government and states were present in Amsterdam. And it was introduced at the initiative of the British Prime Minister. So I think all legislation which is adopted under Article 65 has to be interpreted in this context. And I mean, very shortly after the adoption of that Article 65, all member countries agreed on a political program together with the Commission, which included Rome I, Rome II, and various other measures. So I think they all obeyed to what had been signed into law just shortly before. And what the European Court of Justice in Owusu did, I shall not comment on that. But basically, in relation to all instruments adopted under Article 65, this idea of integration into one market must be present and must be a leading consideration.
Van Heinis is right to this topic, or should we give a...
Yeah, it's to the false conflict topic.
Okay, well, why don't you chime in and we collect 2 or 3 questions and then we give
Yeah,
a chance.
I think that the impression is incorrect that European private international law has absolutely no instrument to deal with false conflicts, because we have instruments in the general part of private international law. For example, the instrument of adaptation, or Angleichung, Anpassung, as it is called in German private international law, or adaptation, as it is called in French private international law. There is an interesting case, for instance, it's about 10 years old. It's a decision by the Court of Appeals of Cologne, where the Belgian child of Belgian farmers was killed in a traffic accident on German territory, and the negligent driver who killed the peasant's son was a Brazilian domiciled in Amsterdam. It's a real case, but it sounds like a textbook case. And the problem that arose was that the applicable law was lex loci delicti, so German law, and German law. The parents, the farmers, claimed damages from the negligent driver because the child had worked on the farm. And they said he no longer is able to render us services, so we claim damages for the services that he is no longer able to render. The problem was that German tort law only gives such a claim if the person who had performed such services was legally obliged to perform services, which is the case under German law. The children of farmers are legally obliged to render such services to their parents as long as they live under the roof. It's a very old rule, but it's still good law. Now, the problem was that since the relationship between the Belgian parents and the Belgian child was governed by Belgian law, this German rule that obliged children to render services to their parents was not applicable. So the court had to look to Belgian law and found that Belgian law does not contain such an obligation. But on the other hand, since the Belgian tort law is modeled on the Code Civil, it had a general clause which would have allowed recovery of damages in such a case. So Belgian tort law would have allowed the claim, and German tort law, if the case had solely been based in Germany, would have allowed the claim as well. So the court said, well, if as a matter of substance Belgian law and German law reach the same result, then the parents should get their money, and it based this result on the figure of adaptation. Now, I know that the writers of the American Conflicts Revolution dismissed all these gimmicks of the general part, such as renvoi, public policy, adaptation. But I think that for the occasionally odd case, such instruments might still have a useful purpose, but such cases are rare. The question is, if we try to have a supranational instrument facilitating legal certainty, predictability of results, do we really need to have a hard and fast black letter rule for each oddball case, so to speak? Or isn't it sufficient that we have some instruments in the general part of private international law which then allow for judicial discretion in such odd cases? And I'm inclined to answer this question in the latter sense.
Well, this is great, except for the fact that, for example, in Rome II, there is no general part.
No, but
Now, if your court is going to incorporate the general part of the jus commune into Rome II, that would be great. But I don't think that will happen. Because if anything, Rome II will preempt the national laws, and maybe it should be read against the general background that would allow the court to incorporate these general principles. But I wouldn't bet on it. I hope so, but I wouldn't bet on it. Now, with regard to false conflicts, I am not saying that European law does not recognize the concept, and this is a very good example of recognizing it obliquely through the general principles. Nor am I arguing, Jürgen, that that Rome II should have adopted interest analysis or the false conflict problem concept. I am very sensitive to the logistical problems you pointed out, that very often to really engage in a balanced and intelligent interest analysis, you have to understand the rationale behind the foreign law and the policies that permeate it and so on. What I am suggesting, though, is that in some cases, the false conflict idea, which is one of only a couple of breakthroughs that American choice of law has contributed to this discipline, the other being issue-by-issue analysis, by the way, that idea should be kept in mind by the drafter of the rule, so that you draft a rule that can resolve false conflicts easily without having to reinvent the wheel. And so the example of the Belgian and French hunters in Kenya, for example, is a good one to say, yeah, if they're domiciled in a state that produces the same result, it doesn't have to be the same legal tradition or the same policy and so on. If under the laws of both Belgium and France, you cannot sue each other because you were in some fraternal society together, some kind of immunity, you don't need to know a lot about the policy under that rule. The fact is that under neither French law nor Belgian law you could recover. Then why should you apply the law of a third state that really doesn't care about this dispute between two foreigners? So what I'm suggesting is that these techniques could be taken into account in drafting the rules, precisely so that judges would not have to engage into the laborious and sophisticated process of policy analysis. And so it is a mishap and unfortunate that small things like these were not taken into account, and they would have improved Rome to some extent, I think.
We're basically back with this discussion to what we discussed this morning, but this is interesting stuff, but that's not what this panel was about. The panel was about is a revolution, the Europeanization of choice of law rules. Does it matter for the United States because of the essentially internal orientation, a market integration, as Richard Fentiman said, should we care? So I would try to push the direction in that, try to push the discussion in that direction. Is that, or do you want to continue the common domicile debate? In which
No, I'll link it to what you saw as the topic of the panel.
Artfully, please.
Okay. The concept of false conflicts assumes first that states have interest in the application of their law, and second, that choice of law should take these interests seriously. The 19th century idea says that states do not have interest in private law, so we never get false conflicts, true conflicts, whatever. We have some change of that in the 20th century in Europe as in the United States with slightly different developments. The Europeanization may lead us to say that under common market ideas, state interests play less of a role in the first place, because what we empower is participants in the common market against public state interests. So there is a deliberate policy of reducing the interference of state policies within the common market, and that translates into choice of law to say, even though we accept that there are interests in true conflicts and false conflicts, that is deliberately not what we focus on, because we want to keep state interests lower. And in that sense, we would have a revolution, because in view of the fact that state interests exist, nonetheless, choice of law deliberately ignores them and can decide to ignore them because it is centralized and not based in the individual states.
I wanted to, this may, there be no one in the room who agrees with this, but I marked down when you had your slides up, this notion that somehow the American rule is, and that interest analysis itself is sort of publicly oriented. There's a view that way, and Americans may think that, but I think, and I hate the term interest analysis. We should abolish it. The breakthrough was very important. That is to say that all you look to is to see if the purpose of this particular law was served. That doesn't necessarily have to say anything about a state interest. It doesn't have to say anything about public international law norms. It just says if the state was drafting this, and I shouldn't even say the state. It's really, is the purpose of this rule achieved? And that, it seems to me, is a common thread, whether you're talking about Europe or the United States. And so I think, actually, I quarrel with your characterization, first of all, of saying that the American sort of development is somehow got issues of sort of public international law or public law. It's unfortunate, the breakthrough that Curry and Cavers both made by sort of moving away from the sort of traditional rules, and in fact looking at these various escape devices like renvoi and public policy and saying, if you look at those cases, what they really were about was saying that this law really didn't apply here, its purpose wasn't served. So I just don't take this, particularly Ralph's sort of characterization of this methodology as a kind of public law approach of the United States. And I really agree with Simeon that there does seem to me to be an attempt to just take sort of purposes of certain kinds of rules and try to reduce them to rules. Indeed, the Neumeier rules were an attempt to do that. If you read the later cases, it's kind of a mess. They've thrown layer and layer on that. But that was the initial attempt, to try to say we don't want to look at all of these particular statutes and see what the purpose are. We want to sort of reduce these if we can, and that's the reason that there's a view that these apply to, drew the loss allocation conduct regulating line. But I'm not sure that that's necessarily a shared view, but in fact, when I teach, I refuse to let the students use the term interest analysis, so you have to use it because everyone else will use it, but I want you to say, is the purpose of this rule further? What's the purpose behind the rule?
There are two sides, right? There's the hardcore interest analysis that Curry was originally after, and that divides Europe from the United States, and then there's your version of it, which is the reprivatized version, which sort of unites them, or just reading a statute in light of its purpose, which goes all the way back to Savigny.
Yes, exactly, that's the point.
So there's overlap, but there's also difference.
Curry's version had disappeared, and what we're talking about, to put it in European terminology, is teleological interpretation,
Yeah,
which the Europeans perfected first.
Absolutely.
So we're learning from it.
Let the panelists get in here.
Well, I was going. Oh, okay. I'm preemptive right. I'm very intrigued by that, Indra, actually, because first of all, of course, what you describe is what we understand by interest analysis. We actually call it domesticated interest analysis. We sort of made it safe, and it's really statutory interpretation. Although I'm bound to say it is statutory interpretation based on expert evidence as to what the meaning of the foreign law is. It's not the judge just taking a view as to what he thinks it ought to mean. What's interesting, though, is you have to ask yourself the question, is even that, which I find very puppyish, is that actually permitted within the rubric of the close connection tests of Rome I and Rome II? Because it's not, you see, and that I think is but if even that is not permitted, then you begin to see my point about the.
If you take, for example, this common domicile exception, it was argued in the German Supreme Court several times, and the court always said, well, there is a closer connection with a common domicile, and then argued for about a page or more about all the interests involved, and because the insurer is at home, and so on and so on. So you are not really limited to some geographical thing. Maybe these people in Brussels, where they have thought so, but now once the spirit is out of the bottle, you can do with it. We are lawyers. We can interpret it the way it should be interpreted.
Well, if I may. Well, I hope so. Thank you. But my worry is this. I have no doubt the German Supreme Court would do that, just as our House of Lords would do that. But I'm not absolutely convinced that the European Court of Justice, when it comes to interpret the principles which govern these exceptions, is going to permit that.
We have two more, Solomon and Hakanen, and I think we're probably maybe out of time, but why don't you two speak one after another, and then we give a chance for the panel to respond.
Okay, it was
So
quite a
long
while
ago,
ago that I kind of remember what I was going to say. I tried to make this intelligible. It is actually concerning what William and Ralf said. We have this development of European integration that is central to the Rome I and Rome II regulations, and it sounded like, or at least possibly also from another remark, that it's directed to the internal relations of the European community. Now, what has happened, of course, is that in the development of the last 10 years, also the policies of the European Union have, on a conflicts level, risen to gain an importance that is much stronger than we would have attached to the policies of an individual state having the identical rules. It most prominent example is consumer protection. We have, based on the directives and the conflicts rules between the directives, developed a system that has a tendency to lead to application of European law or the individual member states' form of European law in situations where we would not accord that application to the law of any other state. And of course, another manifestation of that aspect was once the attempt to reserve consumer protections only to consumers who have their habitual residence within Europe and not to any other consumers. So is that inherent in the development of the methodological further dimension or revolution that we are now facing in the Rome 1-2 regulation, or even if we go even farther, INMA does not really necessarily bear on these two matters? Or is that just a coincidence, a mishap that we will have to fear that the European Court of Justice will further go into that direction? So I share your fears with regard to that.
Yes. My jumping off point is Professor Silberman's explanation of interest analysis as something a little bit distinct from the short version of it, a view that I first learned of in David Curie's comments at the Mercer Symposium, which I had the pleasure of reading recently. Given that formula of interest analysis, it becomes not rules of common domicile or something of that nature, but rather a completely open-ended policy analysis, and as such, it would seem to me very incompatible with what civilian judges have done for choice of law for many years, even before we begin to think about the Rome Convention. If we were to think about incorporating its lessons into the Rome Convention, I would wonder how to even begin to try that without getting into what Professor Reppy would call senseless eclecticism. And so I would be very curious how you might integrate lessons of interest analysis as it is properly done, and also whether that would be accepted as a choice of law methodology by a civilian judge.
I think we have time for two 30-second responses from the panel, and then we have to close. If you have anything to say, if you have nothing to say.
Anything I have to say has more than 30 seconds. So
then you can take a full minute.
Okay. In response, I mean, I was going to make the point, actually, in defence of my Prime Minister at the Treaty of Amsterdam, and it's a related point. I mean, I think the assumption always was that the internal market reference in Article 65 was a limitation on the scope of what the community would do. But that's how it was understood, and I think that is why, if I can mention the case again, that's why Wusu and Jackson is so important as a statement of principle about the nature of European private international law. I mean, that's the point. For two reasons, and it relates to your question, Dennis. That it seemed to me that what they did, of course, in that case, was actually to redefine what the internal market actually was and how it affected the purposes of private international law in two important ways. They said it's nothing to do with territorial connection, in the sense that it doesn't matter where the subject matter of this case is Jamaica, and that we're asking to decline proceedings in favour of Jamaica. That's not the test. Importantly, though, what they appeared to do, and I think this is crucial for the, as it were, the adjudicatory methodology of private international law in Europe, how the Court of Justice will behave, is that what they appeared to do was to say the key issue is not what the Brussels Convention says. It's not actually what the preamble of the Brussels Convention states by way of the purposes of it. The question is, which interpretation of that document is going to best give effect to the internal market? And they said it's the one which essentially creates the most uniform interpretation. But if you take that literally, what it means is that you take an instrument, and what the internal market requires is the literal application of the instrument, and that simply becomes the only test. It's not the purposes of the instrument, as it were, substantively. It's the fact that it creates uniformity, and that's, I think, quite important as a putting down of a marker as to how the Court of Justice will interpret Rome 1 and Rome 2 when the time comes.
Well, on that sinister note, let's end the session and give the panelists